Welcome and thank you for standing by. Your lines have been placed on a listen-only mode until the question and answer session. At that time, if you would like to ask a question, you may press star one. Today's conference is being recorded. If you have any objections, you may disconnect at this time. And at this time, I turn the call over to Craig Aubrey. You may begin, sir.
Good afternoon, everybody. Thanks for calling in today. My name is Craig Aubrey. I'm the Division Chief for Environmental Review at headquarters for the U.S. Fish and Wildlife Service. With me today is Carrie Gall, Chief of our Branch of Listing and Policy Support. We're also joined on the phone today by Kathy Tortorici and Angela Soma of the National Marine Fisheries Service, as well as DJ Monette, our Associate Native American Liaison Advisor. We also have several members of our writing teams on the phone with us today. We're providing today's webinar in the spirit of Executive Order 13175, Consultation and Coordination with Indian Tribal Governments, and Secretarial Order 3206, American Indian Tribal Rights, Federal Tribal Trust Responsibilities, and the Endangered Species Act. The services are offering the opportunity to consult and seek input on these issues that may have an impact on tribal interests. The U.S. Fish and Wildlife Service and National Marine Fisheries Service are proposing revisions to 50 CFR Parts 402 and 424, which establish the procedural regulations governing interagency cooperation and listing species and designating critical habitat under the Endangered Species Act. In addition, the Fish and Wildlife Service is proposing changes to how it designates prohibitions for threatened species. The Secretaries of Interior and Commerce share responsibilities for implementing most of the provisions of the Endangered Species Act. Generally, marine species are under the jurisdiction of the Secretary of Commerce, and all other species are under the jurisdiction of the Secretary of Interior. Authority to administer the ESA has been delegated by the Secretary of the Interior to the Director of the U.S. Fish and Wildlife Service, and by the Secretary of Commerce to the Assistant Administrator for the National Marine Fisheries Service. There have been no comprehensive amendments to the Endangered Species Act since 1988, and no comprehensive revisions to the implementing regulations since 1986. In the years since those changes took place, much has happened. For example, the services have gained considerable experience in implementing the Endangered Species Act, as have other federal agencies, states, tribes, and property owners. There have been numerous court decisions regarding almost every provision of the Endangered Species Act and its implementing regulations. Multiple administrations have adopted various policy initiatives, and the Government Accountability Office has completed reviews of the ESA's implementation. Proposed amendments that we will discuss today are intended to address the service's collective experience of more than 40 years of implementing the Endangered Species Act. And with that, I'm going to pass it off to Angela Soma to give some background on the proposed rules. Thank you.
Thank you, Craig. Hi, everyone. I'm Angela Soma. I'm Chief of the Endangered Species Division at the National Marine Fisheries Service Headquarters Office in Silver Spring, Maryland. As many of you, I'm sure, are aware, Section 4 of the Endangered Species Act provides for how we add to and remove species from the federal list of threatened and endangered species. It also provides procedures for designating critical habitat for those listed species. Our implementing regulations for the listing and critical habitat provisions of the ESA are jointly promulgated, and they are found at 50 CFR 424. And the Fish and Wildlife Service also has protective regulations for threatened species. They have a regulation that provides all protections that endangered species receive for threatened species in a separate part of the regulations, but Section 4D of the Endangered Species Act allows us to promulgate protective regulations for threatened species. Section 7 of the Act is the interagency cooperation provision of the ESA, and it provides requirements for federal agency cooperation and consultation procedures on federal actions and activities. And like with the listing and critical habitat regulations, these are also joint NMFS Fish and Wildlife Service regulations, and they are found at 50 CFR 402. Section 9 of the Act is that section of the ESA that provides for the prohibitions for endangered species once they are listed as endangered, and as I said earlier, Section 4D allows us to also apply these prohibitions for threatened species. Those implementing regulations are for the U.S. Fish and Wildlife Service at 50 CFR 17. The National Marine Fisheries Service does not have specific regulations addressing Section 9. Next, we're going to go to how these proposed revisions were made. They are in part to implement an executive order aimed at reducing the regulatory burden on citizens and promoting innovation. The Department of the Interior and the National Marine Fisheries Service last summer put out broad announcements requesting public input on regulatory reform initiatives. Both services received voluminous comments on potential regulatory reform initiatives, and those comments were considered as these regulations were being considered and developed. In addition, Department of the Interior and Department of Commerce policy officials met with Fish and Wildlife Service and National Marine Fisheries Service Endangered Species Act leadership in December of 2017 to brainstorm potential improvements to the Endangered Species Act, particularly with relationship to the regulations that the agencies have. And an outcome of that meeting was a decision to focus on Section 4, dealing with listing critical habitat, and Section 7 of the Endangered Species Act. Once those regulations were developed and considered within each of the departments, they then went to the Office of Management and Budget and underwent a federal interagency review by multiple federal agencies. So I'm going to now briefly talk about the proposed changes to 50 CFR 424, which deals with listing critical habitat. And the first proposed change has to do with listing, delisting, or reclassifying a species. The definition of a threatened species includes the term foreseeable future. These proposed regulations would create a regulatory framework to interpret and apply the phrase foreseeable future in determining whether a species is a threatened species. The proposed regulations would also clarify that the standard for listing and delisting of a species is the same. Both decisions require us to evaluate the status of the species in terms of the 5 factors that are laid out in Section 4 of the Endangered Species Act. And the proposed change would remove a specific reference in our current regulations to economic or other impacts in our listing classification decisions. Proposed regulatory changes would also deal with how we designate critical habitat and provide criteria for designating critical habitat. It specifically addresses and clarifies when designation of critical habitat may not be prudent. The Endangered Species Act requires us to designate critical habitat for threatened and endangered species when we list them, unless there is a determination by the Secretary that such designation would not be prudent. These regulations also address and revise the process and standards for designating unoccupied critical habitat. The Endangered Species Act allows us to designate habitat that's currently occupied by a species at the time it is listed, as well as unoccupied critical habitat if that unoccupied habitat is determined to be essential to the conservation of the species. So with regard to foreseeable future, again, this is part of the definition of a threatened species, a species which may become in danger of extinction within the foreseeable future. The services have been interpreting this phrase and applying it in our listing decisions for threatened species for many years, and what is in the proposed regulation largely tracks our current practices. It describes that the foreseeable future extends only so far as we can reasonably determine that the conditions that potentially pose a danger of extinction in the foreseeable future to that species are probable. They're not based on speculation. The foreseeable future, when we're making a listing determination, will be described on a case-by-case basis and will rely upon the use of the best available data for each species. Specific timeframes are not necessary. Qualitative descriptions are okay. There are many times in which we will identify a time frame, but that is not always possible given the best available scientific information, and so a qualitative description is okay if that's not possible. based on a reasonable determination that both the future threats and the species' response to those threats are probable. With regard to the proposed changes related to factors considered in delisting, as I mentioned, the intent here is to clarify that the standard for listing and delisting a species is the same, and that is whether a species meets the definition of threatened or endangered as defined in the Endangered Species Act. The regulations clarify that it's appropriate to delist the species when that species is extinct, when it does not meet the definition of an endangered or threatened species, or a listed entity that is a species that is currently listed, it's determined that that listed entity does not meet the definition of a species. With regard to economic or other impacts, as I mentioned earlier, the proposed regulations would eliminate a phrase that's in our current regulations that references economic impacts. The intention here was to align the regulatory text more closely to the statutory language. The specific language that would be removed is a statement without reference to possible economic or other impacts of such determination. The preamble of our proposed regulations reinforces that the determination is still to be made solely on the basis of the best available scientific information and commercial information regarding a species status, but it does identify that impacts information related to economics, if compiled for species, could be used to inform the public of potential costs of listing. With regard to the critical habitat provisions, the proposed regulations address findings when it's not prudent to designate critical habitat. And these proposed regulations lay out a series of instances in which that may be the case. It's not meant to be an exhaustive list. There may be other times when the Secretary makes a determination that critical habitat is not prudent. But in the interest of clarity, we do identify several circumstances in which it's very likely that a determination that critical habitat designation would not be prudent. And that's in the case where there would be an increased degree of threat by informing the public where the species is likely to be found. It could increase poaching threats. Another circumstance would be where habitat impacts are not a threat to the species, or threats to the habitat stem solely from causes not able to be addressed by Section 7A2 of the Act. That's the interagency consultation provisions requirement that federal agencies do not adversely modify or destroy critical habitat. Or in instances where there are areas within U.S. jurisdiction that provide no more than negligible conservation value for species occurring primarily outside of the U.S. And outside of U.S. jurisdiction. And finally, when no areas meet the definition of critical habitat. The Endangered Species Act defines what critical habitat is, and there may be instances in which none of the areas meet that definition of critical habitat. We also are proposing to remove the language regarding designation of critical habitat would not be beneficial to the species. That term, not be beneficial to the species, is not found in the statute. There has been litigation around that terminology, and we believe it would be clearer and more transparent to simply describe instances when designation would not be prudent, rather than trying to make a determination that designation would not be beneficial to the species. These proposed regulations also address designating unoccupied critical habitat. In the 2016 regulatory revisions to this section of the Act, we had made changes to eliminate the two-step process for designating unoccupied habitat. We are now proposing to go back to that two-step process where first you would evaluate the areas occupied by the species, and then we would only consider designating unoccupied areas and consider them to be essential when occupied areas would be inadequate to ensure the conservation of the species, or would result in a less efficient conservation of the species. And in the regulations, what we mean by efficient conservation of the species is that conservation refers to situations where the conservation is effective, societal conflicts are minimized, and resources expended are commensurate with the benefit to the species. So there may be instances where we would designate a combination of unoccupied and occupied critical habitat without first exhausting all of the occupied critical habitat because it would be a more efficient and effective approach to designation and conservation of the species. Again, we only designate unoccupied areas upon a determination that such areas are essential for the conservation of the species. And an area can only be considered essential if the Secretary determines that there is a reasonable likelihood that the area will contribute to the conservation of the species. So the change that we have in these regulations is we've never really laid out in our regulations how we determine whether an unoccupied area is considered essential and therefore open to designation. So now I'm going to turn it back over to Craig to go through the interagency cooperation proposed changes.
Thanks, Angie. So with respect to the interagency cooperation regulations, which is Section 7 consultation is what we commonly refer to it, the proposed revisions would address alternative consultation mechanisms, revise the definitions of destruction or adverse modification and effects of the action, address certainty of mitigation proposed by action agencies, and otherwise improve the consultation process. In addition, the preamble to the proposed rule includes language clarifying that we will be considering comments on the 402 regulations in their entirety, as well as specific aspects of the Section 7 consultation process. So, with respect to alternative consultation mechanisms, one area that the service identified for opportunities to improve and streamline the consultation process is through the development and use of these mechanisms. Over the years, the services have worked with other federal agencies and others to develop a variety of options to the traditional approach to consultation. In this proposed rule, we're proposing to codify some of the approaches that we have developed and to promote their use as effective tools that can improve both process efficiency and conservation. To address the alternative consultation mechanisms, we propose to define programmatic consultation in the regulations and discuss various types of programmatic consultations in the preamble. We provide examples of different types of programmatic consultations in the proposed rule text. We're also proposing to add 2 new provisions to the regulations to allow the services to adopt all or a part of a federal agency's initiation package or the services analysis and findings that are required to issue a permit under Section 10A of the Endangered Species Act and their biological opinions. We are also inserting a new provision, expedited consultations, to offer opportunities to streamline consultation, particularly for actions that have minimal adverse effects or predictable and straightforward effects based upon previous consultation experience. In order to use this alternative process, this expedited consultation, 2 things would be needed. First, there needs to be mutual agreement between the services and the federal agency to enter into this process. And secondly, the federal agency needs to provide all of the necessary information to initiate consultation. For clarifying effects of the action, first we're proposing to revise the definition of effects of the action to simplify the definition in order to assist federal agencies and the services, tribes, applicants, and others as they assess the effects of the proposed action. Confusion regarding application of terms has resulted in time being spent determining how to categorize an effect rather than simply determining what the effects are regardless of category. By providing a simpler definition that applies to the entire range of potential effects, federal agencies and the services will be able to better focus on assessing the effects of the proposed action. Proposed revisions include collapsing the concepts of direct and indirect effects and the effects of interrelated and interdependent actions into the new definition, including additional direction that an effect or activity is caused by the proposed action when two tests are satisfied. First, the effect or activity would not occur but for the proposed action, and second, the effect or activity is reasonably certain to occur. As we note in the preamble to the proposed rule, if an effect or activity would occur regardless of whether or not the proposed activity goes forward, that effect or activity would not satisfy the but-for test and is not considered to be caused by the proposed action. While we discuss this more thoroughly in the preamble to the proposed rule, activities or effects that are reasonably certain to occur cannot be speculative, but they also don't need to be guaranteed to occur. To clarify this term as it applies to activities, we're proposing to add a new section to our regulations, and within that section we're proposing a new provision titled Activities that are reasonably certain to occur, in order to clarify the application of the reasonably certain to occur standard referenced in the definitions of effects of the action and cumulative effects. This new proposed provision applies to activities caused by but not included in the proposed action and activities under cumulative effects. Next, we are proposing to make the unchanged definition of environmental baseline a standalone definition within the regulations. Previously, this definition was articulated within the definition of effects of the action. Moving it to a standalone definition clarifies that the environmental baseline is a separate consideration that sets the stage for analyzing the effects of the proposed action on the listed species and critical habitat within the action area, by providing the foundation upon which to build the analysis of the effects of the action under consultation. Third, we're proposing to revise the regulations to clarify what is necessary to initiate formal consultation and further describe the information necessary to initiate consultation. Consistent with our existing practice, this will ensure that we have enough information to understand the action as proposed and conduct an informed analysis of the effects of the action. One thing that's important to note is that we're not actually trying to increase or decrease what information we're looking for, but actually just clarify what we're looking for to help streamline and expedite the consultation process. We're also clarifying that the services are allowed to consider other documents as initiation packages, such as a document prepared pursuant to the National Environmental Policy Act, as long as those documents meet the requirements for initiating consultation and provide a sufficient level of detail consistent with the nature of the scope of the proposed action. And so now I'm going to turn it over to Kathy Tortorici, who will be providing some background on our proposed revisions to the definition of destruction or adverse modification.
Thanks, Craig. And just for folks on the phone, I'm the chief of the ESA Interagency Cooperation Division here at the National Marine Fisheries Service based out of Silver Spring, Maryland. So in 1986, the services established a definition for destruction or adverse modification that was found to be invalid by the U.S. Courts of Appeal for the 5th and 9th Circuits in 2001 and 2004. In 2016, we revised the definition in part in response to these court rulings. We now propose to further clarify the definition, removing language that's redundant and has caused confusion about the meaning of the regulation. As with the 2016 rule, we don't intend our proposed change to alter existing Section 7A2 consultation practice. Instead, the proposed definition retains the key operative first sentence of the 2016 regulation and adds a clarifying additional phrase of as a whole. We're proposing to revise the first sentence of the definition by adding this phrase as a whole to clarify the appropriate scale of the destruction or adverse modification determination. This was previously included in the preamble of the 2016 rule. So in this next slide, I just want to read the definition to you. Then this is the new proposed definition. Destruction or adverse modification means a direct or indirect alteration that appreciably diminishes the value of critical habitat as a whole for the conservation of a listed species. And once again, the second sentence of the 2016 definition has been removed, and we've added that phrase in the first sentence, as a whole. The next item that I want to talk about addresses certainty of mitigation. So judicial decisions have created confusion regarding what level of certainty is required to demonstrate that a mitigation measure will in fact be implemented before the service can consider it in a biological opinion. It's our belief that if a federal agency provides information in sufficient detail for the services to meaningfully evaluate the effects of measures proposed to avoid, minimize, or offset adverse effects, the services are entitled to rely on that information as proposed. Therefore, we're proposing revisions to Part 402.14C1 with respect to the information a federal agency must submit to initiate consultation. Under this proposed rule and consistent with our existing approaches, a federal agency must submit a complete description of the proposed action, including available information about any measures intended to avoid, minimize, or offset effects of the proposed action. Given that, provided that the federal agency submits the information required by 402.14C, the services will take into consideration the effects of the action as proposed, both beneficial and adverse. Back to you, Craig.
In order to otherwise improve the consultation process, we're proposing to clarify the analytical steps the services undertake in formulating a biological opinion in a manner consistent with our existing approach, as well as addressing our proposed revision to the definition of effects of the action. Secondly, we're proposing to remove the term formal from the title and text of 402.16, which is reinitiation of consultation, in order to acknowledge that the requirement to reinitiate consultation applies to all Section 7A2 consultations. By practice, action agencies have reinitiated informal consultations when a trigger for reinitiation has been met, and courts have also held that reinitiation is required in the context of informal consultation. Third, we're proposing to amend 402.16D to eliminate the need to reinitiate consultation on certain land management plans upon the listing of a new species or designation of new critical habitat, provided that the authorized actions that would result in the effects to the newly listed species or critical habitat will still be addressed by project-level consultation. This proposed amendment addresses issues arising under the Ninth Circuit's decision in Cottonwood Environmental Law Center versus the U.S. Forest Service. After decades of experience cooperating with action agencies across the federal government, we've gained the expertise of when reinitiation of consultation is most effective to meeting the overall goals of the Endangered Species Act, and reinitiating on a purely programmatic land management plan when new species are listed or critical habitat is designated does little to further these goals. So we're thus providing to exercise our discretion and narrow 402.16 to exclude two types of plans that have no immediate or on-the-ground effects. With respect to this Cottonwood language, we're also seeking comments on whether to exempt other types of programmatic land or water management plans, in addition to those addressed in the proposed rule, from the requirement to reinitiate consultation when a new species is listed or critical habitat is designated. We're also seeking comment on this proposed revision in light of the recently enacted Wildfire Suppression Funding and Forest Management Activities Act, which was included in the fiscal year 18 Omnibus Appropriations Bill. We're also seeking public input on several other potential revisions to the consultation process. And so for these items here, we don't actually have proposed regulatory text at the back of the proposed rule, but we are taking comment as outlined within the preamble to the proposed rule. First is establishing a deadline for the completion of informal consultation. Secondly, codifying the ability to conduct a single consultation resulting in a single biological opinion for federal agency actions affecting species that are under the jurisdiction of both Fish and Wildlife Service and National Marine Fisheries Service. So an example here might be listed sea turtles. Third, revising the definition of environmental baseline as it relates to ongoing federal actions. So I described earlier how we were proposing to make the definition of environmental baseline a standalone definition, and if you read within the preamble to the proposed rule, we also talk about potentially looking at how to address ongoing federal actions. Fourth, clarifying the circumstances upon which federal agencies are not required to consult. And fifth, limiting the scope of a consultation to only those activities, areas, and effects that are within the jurisdictional control and responsibility of the regulatory agency. So that concludes our overview of the interagency cooperation regulations. And now I'm going to turn it over to Carrie Gulls to give an overview of our other proposed rule.
Hi, everyone. So the Endangered Species Act has a list of prohibitions under Section 9 that are applied to all endangered species. And in the 1970s, the Fish and Wildlife Service promulgated rules that apply those Section 9 prohibitions to all species that were listed as threatened species. And this rulemaking, located at 50 CFR Part 17, would rescind those regulations that automatically apply the prohibitions for endangered species to threatened species. And this change would be forward-looking, so it wouldn't affect any of the species that have been listed in the past as threatened species that may have invoked those rules. So our change will be to change the protections and prohibitions for species that we list as threatened species in the future, where we would promulgate a species-specific 4D rule that would allow for prohibitions and protections that are necessary and advisable for that particular species. This is something we've been doing for about the past decade and would align our practice with the National Marine Fisheries Service. We have found that there's been many benefits that we can realize when we do these species-specific 4D rules. We remove redundant permitting requirements. It facilitates the implementation of beneficial conservation actions, and it better uses our limited personnel and fiscal resources. So this rule, again, would rescind those current regulations that automatically apply the prohibitions for endangered species to threatened species and would only be forward-looking for newly listed or classified species as threatened species. So this is our last change here and last part of the presentation. I just want to remind you all that we do have an open comment period right now on all three of the rules. The comment period is open until September 24th. So if you have comments, you can provide us comments through the regulations.gov dockets. And then I think we'll open it up for questions on all three of the rules, Shirley, if you're ready to take questions.
Thank you. We will now begin the question and answer session. If you would like to ask a question, please press *1. You will be prompted to record your name. To withdraw your question, you may press *2. Again, press *1 to ask a question. And one moment, please, for our first question.